A New York appeals court recently ruled that forcing landlords to accept Section 8 vouchers is actually unconstitutional. This affects 343,000 New Yorkers, so here's where things actually stand a few months in. There's new articles coming out and whatnot. So a quick refresher on what Section 8 is. The Housing Choice Voucher Program is a federal HUD program that helps low-income families, seniors, veterans, and people with disabilities pay rent in the private market. Tenant pays 10, 20, 30% of their income, and the government voucher will cover the rest. About 343,000 New Yorkers use it, including 123,000 New York City households. So in 2019, New York passed a law banning landlords from rejecting tenants based on source of income, which specifically included Section 8 vouchers. New York City had passed a similar city law years earlier. Landlords who refuse Section 8 tenants could be sued by the AG. That's what happened to Jason Fain, an Ithaca landlord who sued back, arguing the law violated his Fourth Amendment property rights. On March 5th, the New York Appellate Division, 3rd Department, unanimously sided with Fain. The court's reasoning is that to accept the Section 8 tenant, a landlord must allow government inspections of the property and give the government access to financial records, both without a warrant, and the court ruled that compelling that consent violates the Fourth Amendment's protection against unreasonable searches. The court was careful to acknowledge that Section 8 is a critical tool for affordable housing and that the law's goals were laudable, but ruled the law itself was unconstitutional on its face. Now here's where things actually stand today. AG Letitia James filed her appeal. The case is heading to New York's highest court, the Court of Appeals. The 3rd Department ruling is binding statewide for now, but New York City's separate city law banning source of income discrimination is technically still in effect. Lawyers and judges are split on whether the state ruling overrides the city law in the 5 boroughs. So the practical reality right now is that New York City landlords who don't want to participate in Section 8 are in legal gray area. New York City voucher holders trying to use their vouchers are in that same gray area. Until the Court of Appeals weighs in, both sides are kind of operating without clear guidance. So what this means going forward: if you're a small New York City landlord, talk to a real estate attorney before changing your acceptance policy. If you're a voucher holder, the 123,000 New York City voucher-using households still have city protections that have not been struck down. NYCHA continues to administer the program. Section 8 has not been eliminated. The ruling only addresses whether the state can force acceptance, not whether the program itself functions. This is one of the biggest housing cases in New York in a decade. We will watch to see what happens with the Court of Appeals. Share this with anybody who's a landlord or voucher holder in New York